Representatives versus Governor Mark Dayton and Commissioner Myron Franz.
Governor Doug Kelly from Kelly, Wolter, and Scott on behalf of the legislature. I have with me here Steve Wolter and Kevin Magnuson from my office, and also Brett Kelly, who's here.
All right. Your Honor, Sam Hansen, representing Governor Mark Dayton and Commissioner Myron Franz. With me at council table is the Commissioner Myron Franz, my partner Scott Flaherty, Scott Knudsen, and Emily Peterson in the jury box. All right, thank you.
Well, I know there's a motion for judgment on the pleadings by Governor Dayton, but this is a response to an order to show cause, so I think we'll just go in pleading order, and we'll start with the plaintiff.
Thank you, Your Honor. I represent the entire Minnesota legislature here today. And we are here because on May 30th of 2017, the governor effectively eliminated the Senate and House as functioning bodies by vetoing all funding for the core of the legislative branch for the next 2 years. So we have brought a declaratory judgment action asking this court to declare the vetoes null and void. The governor did not veto these appropriations because he objected to the appropriation. In fact, his budget proposal proposed the exact same amount. He vetoed these provisions to coerce the legislature into concessions on unrelated provisions, some not even having anything to do with appropriations, that he had already signed into law. Make no mistake about it, Your Honor, we are at an impasse. The governor has said, I will call the special session only if you agree to concede on the following 5 items. My client has said we are not going to negotiate while we have a gun to our head.
Have the parties considered a third-party mediator, perhaps a retired judge?
We have not. And I think, so what we have done, Your Honor, is with regard to this impasse is what, and I'm lucky to have opposing counsel, former Justice Hansen with me, we have tried to set this up so that this court can break the logjam, make a ruling, and do it, and we'll all go back to our respective positions as quickly as possible. This whole issue of the power of the executive, and I know Governor Dayton, when he announced his veto, said, I have a line item veto and there are no constraints on that power, and that is the position that Mr. Hansen has taken in his briefs. This whole issue of the power of the executive goes all the way back to Montesquieu. And way back at the time when they were looking at the separation of powers and the independence of the various parties.
But did Montesquieu have a line item veto in the Constitution?
Well, here's the deal, Your Honor. Here's what he said, and I think this is important for us, that the branches have to be independent, lest the executive sword become a, quote, sword of Damocles, precariously and intimidatingly suspended over the other branches. That's where we are here today. My clients have this veto, and the veto will require them, it would start next week, would be the first furlough notices, which would have gone out had we not been able to narrow the issues.
So if the governor thought that the legislature was engaging in an unsound fiscal practice, spending too much money on itself, what power then would the governor have to control that but for the line item veto?
He could have vetoed the entire bill.
But he's only concerned theoretically with the excessive spending on the legislature.
Well, but that's not really true. I mean, as if you look at the things that he's asking for a concession on have to do with teachers' licensing procurements.
That's the reality. I'm just saying that if I were to accept your argument as true, that the governor is categorically prohibited from using the line item veto to cross out the legislative appropriation, wouldn't that also take the so-called baby out with the bathwater, and now the governor is deprived of having any check on excessive or extravagant legislative spending on itself?
No, I think that this will not have future effect on other cases. This is a one of a
It's really
kind.
assuring right now. But anything is possible, and we've seen that play out in real life. So where's the governing legal principle that I could use to draw this line that would make me more comfortable with what you just said?
Do you mean, how do you draw the line in an order if you grant the order that we're asking?
No, I mean, what you're saying is that I don't have to worry about throwing this veto out and still having the governor retain authority to control excessive or extravagant legislative spending on itself. Where is the governing legal principle that would allow me to navigate that distinction?
I'm going to get to that. And I come to the separation of powers, and that separation of powers, we believe, is dispositive and gives you the power to do this. Do it this time. As far as we can tell, this is really unique. New Mexico has just gone through a little bit of an issue, but there the governor called them back into special session, so the court said, hey, we ought to stay out. But I think Mr. Hansen and I have explored everything, and we have not had any discussions about resolving this issue other than getting it teed up to this court so you can make a decision quickly. We have worked hard last week to do that. The line item veto here was adopted by the state of Minnesota in 1876. And in the ensuing 141 years, no governor has used this line item veto this way, and for good reason, because it so obviously violates the separation of powers. Now, Your Honor, what I thought I would do this morning is, and I know you have read the stipulation, but I thought I would just go through a little bit to let you know what our thoughts were and how we think the stipulation affects what's going on.
All right.
Is that appropriate?
That's fine.
Reading all the cases going back where you had, and the court has already noticed them, where you go into the whole issue of core functions and their special masters and all of that. I think Mr. Hansen and I thought that the best way to get this to you would be like a silver bullet. Get a question here, get it to you so that you can decide it, and then both sides agree. Whichever wins or loses, that the other side will help and will go straight to the Supremes. And this was our best guess as to how to do a few things. How to save the bond rating. We think 90 days worth of comfort will help them, and that was very important to the governor. My clients do not start sending out their things, their furlough notices next week and have 500 people's lives be interrupted. So here's what we did. We said, let's get count one. And by the way, when I was drafting the complaint, there were discussions of all kinds of other things, and you've seen them in the other cases, single subject matter in the bill, the whole issue of pay raises, all that. I drew this complaint with one thing in mind, and that is to try to get a simple, quick question to the court. So we've decided that count one of the complaint, we believe it's right, and we believe it is ready for the court to decide. And we ask in count one also that you put injunctive relief for whoever is the winner, and we believe that will help ensure the appealability of the count immediately, if there's any question about the declaratory judgment. In paragraph 2, we ask you to go forward.
Before you go on,
Okay.
There's injunctive relief to require payment at the 2017 fiscal rate.
Correct.
Through October 1st. Are you talking about a second form of injunctive relief that would go with count one?
No.
Okay. Just wanted to clarify.
Second, Your Honor, is going through, you entered judgment without delay, and we put that in for Rule 54.02, and then that would have the effect, we hope, that if you accept the stipulation, that we would put off counts 2 and 3 for the remaining time. And that would alleviate us having to go through all the core function and all those arguments. Both sides agree to seek accelerated review, and then under this, there would be, the pay would continue under 2017 levels for either through the appeal or to October 1, whichever occurs first. And also we agree that there would be no bond required in terms of that. Important to the governor was that we pay all of our obligations, and so we have agreed to do that. And we have also agreed to pay the payments on the Senate office building. So there are those payments which would come. One is on July 30th, and then we have June 30th, July, August, and September. And interestingly enough, according to the argument you had, the last paragraph, paragraph 8, says that we are able to, we have an agreement that we are able to, but not required to use the carry forward funds in order to make the payments. So that's the.
And are you looking for that in the order as well? Because that paragraph appeared to stand on its own as a private agreement between the parties. It was separate in the stipulation.
Well, we have it in the, I have a proposed order here, Your Honor. And I think that we anticipated that that would be part of the order.
Paragraph 8?
Yes.
Okay.
Yeah, and can I give
You
the
may.
court,
You may.
we drafted this yesterday. I did not have a chance to have, to get this to Mr. Hanson earlier, Your Honor, so he has not had an opportunity to discuss it.
All right.
Court would also note that I did not bring a TRO. Part of that was because we know about the carry forward and other kinds of things. And I think the last part of this agreement, which I think is a good agreement for the people of Minnesota, is that it will fund things and people will not be put out of work. So we would ask that you adopt that stipulation, and if I've said anything inaccurate, I'm sure Mr. Hanson will correct me. Now, let me turn to the merits. And I start, I noticed you mentioned this in the first case's argument today, Your Honor, that we're here with the declaratory judgment under Chapter 555, specifically because the Minnesota Supreme Court said that's where you go. We did not try to get directly to the Supreme Court, and we think it was better to come straight to here.
Well, I think the underlying cause of action supporting a declaratory judgment case is the challenge to the constitutionality of the veto.
Correct.
So I'm tracking perfectly what the Supreme Court has said in those cases.
So when we get to the separation of powers clause, I mean, this was a provision in our federal constitution before Minnesota became a state. As I mentioned, Montesquieu had a great deal of writing about it. Madison and Hamilton described it extensively in the Federalist Papers. And Minnesota followed the federal model when it adopted its constitution in 1857. Article 3 specifies that the powers of government shall be divided into three distinct departments: legislative, executive, and judicial. And then the second sentence says, no person or persons belonging to or constituting one of these departments shall exercise any of the powers properly belonging to either of the others, except in instances expressly provided in this Constitution.
Which is what we're arguing about. That's the line item veto authority. So
Correct.
You would agree the line item veto is part of the separation of powers analysis.
Sure. Yes.
Because the distinction between the two arguments that I'm hearing from you is very narrow. I mean, you're arguing that I can consider the reasoning behind the line item veto, and if it's for the wrong reason, it's an invalid veto. And the governor's arguing that I have an unfettered line item veto authority, and the courts can't consider the motivation behind it.
And
Isn't that the line between the two sides?
It is. It is. And I think we'll be able to show that there clearly are limitations to this, and it has come from our court and from other courts in other states. So it was first tested in Minnesota in 1865 during the Civil War. The Minnesota Senate sent over a bill and said, tell us if it's constitutional or whether it will pass muster. And the Supreme Court said that they would not do it. And it said we have to respect the duties of the branches. And this is one of the first cases that helps delineate these. And it says it is the duty of each branch to abstain from and to oppose encroachments on either. Any departure from these important principles must be attended with evil. They used interesting language in those days. That was the first time, but that we cite in our brief many others, and I won't go through them all, but more recently the Supreme Court has said in Brayton versus Palente, the separation of powers clause expressly prohibits each branch from usurping or diminishing the role of another branch. So it has continued on down through. In our view, since the governor has essentially obliterated the legislature for the next biennium, you don't need to go any further. We don't have to talk about the intent. I'm going to talk about the intent because it's relevant to the line item veto itself, but we could stop right here. I think I could stop, sit down and rest and say, this is improper, impermissible, and most courts would say, yes, that's true. However, the governor made his intent known when he vetoed it. Now, when we look at the line item veto, which I saw was adopted in 1876, it was put into the legislative article, Article 4. And the Supreme Court has interpreted that recently to say it demonstrates it's an exception to the legislature's authority, and it is not a specific grant to others. And here's the term. It is therefore limited and, quote, must be narrowly construed to prevent an unwarranted usurpation by the executive of powers granted the legislature in the first instance. Now, if we look at the language that was adopted in 1874, it didn't use the word veto, 1876. And it says, and the language is important, if any bill presented to the governor contains several items of appropriation of money, so there's a limitation, he may object to one or more of such items while approving the other portion of the bill. So object to was the word. It didn't say veto in the original one that was passed. In such case, he shall append to the bill at the time of signing it a statement of the items to which he objects. Notice again the use of the word objects, and the appropriation so objected to shall take effect. Now, this was changed in 1974 when we had a constitutional amendment or article come up, and I think it was Senator Jack Davies who kind of wanted to modernize the Constitution. They tried to put it into a form that's much more readable. And when they did that in 1974, they used the term veto instead of the term object to, which was in the original language for the line item veto. However, at the time that the constitutional amendment was voted on, and also after it has been litigated, they put this language in there to ensure that the supposed stylistic changes would not change the substance of what had gone on before. And so we've cited in our brief, and it says, if a change included in the proposed amendment, the 1974 amendment, is found to be other than inconsequential by litigation or after the submission of the amendment, the change shall be without effect. So we believe that when you evaluate the line item veto today, the original intent of the framers of the amendment still say you have to object to something.
Well, isn't that what a veto means? It's an objection.
You have to be opposed to something, Your Honor.
I think the governor has made that clear.
But no, he did not. What he did was he said, and I think he's made public pronouncements, and I didn't put these here, he said, I don't mean to unfund the legislature. I want them to come back to the table and negotiate. But here we have the letter. This is Exhibit 1, which is in my complaint. And this is not just a casual letter between friends. This is the formal document that was referred to in the line item veto language. So this is what came with the veto when the governor sent it back to the legislature.
And would you agree or disagree that Exhibit 1 is the constitutionally mandated statement of objection? Or was
I would say it is the constitutionally mandated.
Okay.
It's his reasons for what he does.
Okay.
Okay. So, and in this, so it has the, as you can see, it has the two lines that he's vetoed, and he says at the last minute, the legislature snuck language into the state government bill that would hold hostage the Department of Revenue appropriation. I am unwilling to put the jobs of 1,300 Department of Revenue employees at risk. As a result of this action, I am line item vetoing the appropriation of the Senate and the House of Representatives to bring the leaders back to the table to negotiate provisions in the tax, education, and public safety bills that I cannot accept. So he's not saying I don't want you, or I disagree with the appropriation or the amount or anything else. He is saying basically I'm doing this for leverage over you. Then he also
isn't that one of the purposes of a line item veto? I mean, I've been trying to think about why you would veto something, and I sort of thought about two categories. There's the over my dead body veto, which would, I'm not going to sign this no matter what form you put it in. And then there's the I want you to do what I want you to do veto. I like your ideas, but you didn't write it properly, or there's not enough money, or there's too much money involved. So it's the let's meet and compromise coercive veto.
what we're saying
Aren't those
is,
both legal uses of a veto?
no, the second one is not. And the reason is the line item veto has to do with appropriations. You don't get a line item veto to line out items in a public safety bill that you don't like. It's supposed to be an item of appropriation. That's one of the limits. It comes right from the language of the amendment adopting the line item veto. And you have to object to what you're doing. So when he line item vetoed the legislature, he had already sent up his budget proposal, which contained the same amount. All the way through, those amounts stayed the same. So it's clear to us he's not objecting to the $131 million for the legislature. He's just purely trying to get them to the table. And
Which, again, isn't that one of the purposes of a veto?
no. Well, it can be in other instances, but it can't be if you're holding a gun to the head of the legislature and threatening to obliterate another branch of government. So now, attached to the other letter was a second letter that goes to Kurt Dowd, the Speaker of the House, and Paul Gazelka, the Senate Majority Leader. And he gives a little bit more explanation in this. Once again, dated May 30th, and this is part of Exhibit 1. I am signing into law the 9 so-called budget bills in order to forestall a bitter June showdown over a state government showdown. Then the next paragraph. I will allow the tax bill to become law without my signature. I will not sign it because of very major objections I have with certain provisions in it. Then it says, however, I cannot veto it because of the poison pill provision you snuck into the state government bill. Now, that's just dead wrong. He could have vetoed it. If he thought that was wrong, he should have just vetoed the whole bill, and then the parties would go back into their respective positions and they would negotiate, and we wouldn't be here to talk with the court. He considered other options
You
as
might
well.
be here, but you'd be talking about something else.
And it's also interesting to me that he considered another avenue of challenge here. And he said, in a paragraph down, I will not risk a legal challenge to the Department of Revenue's budget and cause uncertainty for over its over 1,300 employees. So he looked at all his options at the time and said, well, I could veto it, I can do this, and he chose what I call the nuclear option. I'm going to obliterate you and your ability to conduct business for the next 2 years unless you come to the table. That is an impermissible use of the appropriation line item veto. And we are going straight with the text of the language in the original 1876 amendment. Now, and we have at no place said, Your Honor, that the line item veto itself, that power is unconstitutional. We're saying the way it was used in this case in order to overstep the boundaries of the separation of government is where it goes afoul.
Well, the previous cases discussing the constitutional test for a line item veto have simply said, is it an appropriation and is it specific and certain? And doesn't this qualify?
No.
I mean, on a technical basis, it was a specific and certain and it was appropriation. So based on the case law to date, it's technically a valid line item veto, isn't it?
It's an appropriation, a veto of an appropriation, but but not in conformance with the 1876 amendment. And that is, you have to object to it. He doesn't object to the appropriation itself. He has communicated that in several different ways. This is, I am going to reach across and I'm going to obliterate you in order to have a better negotiation or negotiating position going forward. Now, if you go to the case law.
So if he had simply said, I object to the legislature's level of funding, I'm vetoing it, that would have been valid.
Well, no, as I said earlier, I thought I could have stopped without talking about the reasons, because you can't obliterate another branch of government. You just can't do that.
Which gets back to the first question I asked you. What constitutionally permissible way, then, does the governor have to rein in what the governor perceives as excessive spending by the legislature on itself?
When I read to you what was going on, where the governor said, I can't veto this bill, he could have vetoed that bill.
No, I'm talking about the appropriation to the legislature.
Listen,
You're
Your
arguing
Honor,
that the governor can't veto the legislative appropriation to run the legislature.
if he vetoed, and I know my opponents have put a couple of the costs in there, so there's $3,000 in there for a chaplain. And there's money for state travel and other things. If he had vetoed those and said, I think these are excessive, perfectly acceptable.
But there's no opportunity to do that because the entire legislative appropriation is in a single dollar amount, or actually two, one for each house, without an itemization underneath it. So if you think there was overspending in any way, whether it be a small item or across the board, the only option the governor has is to veto it. And if I take your argument to its natural conclusion, you are then telling the governor you cannot constitutionally control excessive spending.
If the governor said, I'm vetoing it, and I'm vetoing it because I don't like the expensive copiers you have, I would not be here in front of you today. When he vetoes the entire appropriation, it disables my clients from fulfilling their function. So I'm saying this is a very narrow exception. And as I said, 141 years, no other governor has done this. This is kind of the nuclear option.
So in what sentence would you phrase the governing legal principle that you're here explaining me today?
I would say to you that I'm going to talk to you about two cases today. One is Brayton, and the second one is the West Virginia case, which I sent to your chambers hopefully yesterday. And that will give the answer and where I'm coming with this to help the court. So you recall in Brayton that there was a big, Governor Plenty, there was a $4.5 billion deficit. The legislature passed appropriations to reduce that to 2.7. Then they passed a tax increase that would have raised the additional amounts to balance the budget. The legislature adjourns, and then Governor Pawlenty unallots $2.5 billion worth of things, and then we end up in court. Now, the unallotment authority, just as the line item veto authority, is legal, constitutional, and proper when it's used in its appropriate fashion. Nobody would contest that. But as the court said, You know, there is an appropriation process here, and the governor has his role and the others have their role. And by using the unallotment to essentially usurp the legislature's power, the unallotment is the court didn't say the statute's unconstitutional, but the use of the unallotment was unconstitutional and a violation because they encroached on the legislator's appropriation powers. That is the analogy that I'm using here. Once again, not saying that the line item veto itself is unconstitutional. It's its use here, and especially when it's used to either obliterate an entire other branch of government or to get an unfair advantage in negotiation. Now, the second case, interesting case, the case of Brotherton versus Blankenship, which was out of West Virginia in 1973. I'm not used to going to West Virginia for authority, but when I read it, I see it's pretty close in many different ways to our case here. There were several things going on. The governor line item vetoed portions of the judiciary's appropriation. And by the way, there's a kind of a special statute that protected the judiciary there.
It really caught my interest. It said
I bet it did, Your Honor.
no one can reduce the proposed budget submitted by the judiciary.
Well, and very interestingly, I happened to be present at the Capitol when Chief Justice Lori Gilday came and testified in front of the legislature this time for her appropriation. And so she said, no Chief Justice has ever been here before, but I'm here because this is so important. And the second thing that went on, the governor in West Virginia also used his line item veto to zero out the operating budget for the treasurer and the secretary of state. But interestingly, he left their personal salaries intact. And so they went to the West Virginia Supreme Court. Again, the governor argued just as his arguing here. They said that the line item veto was, quote, without limitation, unquote. Where does it show us? Then there was some interesting language in the case, too. And so the governor, in his brief, says, it's ridiculous to even consider that he would act in such a manner as to render such department inoperative. And then the court said, so basically the court said, with regard to the judicial veto, we're hanging our hat on the statute some, but we're also turning in, we're doing it just on separation of powers. And so they said, to adopt the view of the intervener, who's the governor, a governor would effectively curtail or could effectively curtail or even eliminate the legislative and judicial branches. Though such action by a governor is most unlikely, we cannot subscribe to an interpretation of the line item veto under which that contingency is a possibility. Then with regard to the constitutional officers, the court said, reducing the accounts to zero effectively abolishes those functions. And that's what's happening here.
Was there any indication, though, in the West Virginia case that the governor would restore those items with further negotiations with the legislature?
Couldn't tell that from the opinion,
Okay.
Your Honor.
The reason I ask is because of the issue of a political question, particularly in light of the agreement, and this was in both of your briefs before you reached your stipulation, the notion of temporary funding. And you're both citing the orders that have been issued out of this court over the last 17 years, providing for temporary funding. If temporary funding is provided by the courts and the parties can go on and litigate, or not litigate, but resolve through negotiation their political dispute, why should the courts get involved?
Well, first of all, we're not there. We're presenting the question to you here today. Please say yea or nay on the constitutionality on the basis of the separation of powers of count one. We all recognize we could get there, but I don't think that doesn't destroy justiciability or ripeness or anything else. It's a remote possibility, and I don't think it's appropriate for somebody to say one branch of government, you go hand in hand to another branch of government to continue your existence. And let me turn that a little bit, Your Honor. So what if, and this has not happened here, but just as we speak hypothetically, what if before the session ended, the Supreme Court came out with a decision and the governor disagreed with it? Governor vetoes the judiciary's appropriation and says something to the effect, well, I'll help you restore your funding if you do something about your bad case that I don't like.
Well, if you look at my notes, I had that question planned for Mr. Hansen, so.
Well, I hate to pose that possibility, but when you say the governor has unfettered discretion to use this and can't he use it to do anything, and here's what the court here said with regard to this. There is a respectable line of authority which holds that the discretion vested in the chief executive by the Constitution is not subject to control or review by the courts. And there's a whole section in Mr. Hansen's brief on those cases, and you've cited one of them here. I agree with that. 99.99% of the time, those cases govern. You wouldn't ever go behind and look at the intent. Here's what the Virginia Supreme Court said. While we agree with the above principle, it must be noted in addition thereto that executive actions of a governor are not subject to judicial interference so long as such actions fall within the sphere of his lawful authority. However, when a governor clearly abuses his discretion or when he refuses to perform a purely ministerial duty, the above principle becomes inoperative and it becomes the duty of the courts to define the safeguards against the abuse of power as provided in our Constitution. And
What's the purely ministerial duty here?
Well, it's not. I should have left that phrase out, Your Honor. I said when I read the quote, when a governor abuses his discretion, that's the portion I'm relying on. Then it becomes.
I'm doing my best to listen.
Right. Thank you, Your Honor. And that's my argument. That is it. In this case, we do not say that the line item veto is unconstitutional of itself. It's just this use. And as I said earlier, 141 years and nobody has done it. And there's a good reason for that. And we believe it's because it so obviously crosses the line. I'll sit down now and unless the court has other questions.
No, I'm fine. All right.
Morning, Your Honor. May it please the court, counsel. There's a false premise that underlies all of the arguments that Mr. Kelly is making. And that is that the legislature has been left without funding. And that's not true. An appropriation may be equivalent to funding, but it isn't always. We've learned that in the 3 prior cases where the legislature itself put a gun to the head of the court and the executive body and did not appropriate funding. The court has held, and I think our jurisprudence in this state is that you don't have a constitutional right to an appropriation, but you do have a constitutional right to funding. Nothing the governor did here deprives the legislature of funding for its critical core functions to operate as a constitutional body. And we've been here before. As you mentioned, the 3 times, 2001, 2005, 2011, now 2017, we end up with the legislative session ending with somebody not getting an appropriation. In some of those cases, it was just executive agencies. Sometimes it was the court and the executive. Sometimes the legislature was included because the governor in those cases vetoed the whole entire appropriation bill. Nobody said this was a violation of separation of powers to either have failed to appropriate or to veto the whole appropriation bill. And it isn't because the constitutional right is to get your core funding. And this court, through the earlier 3 cases, ruled that even though the Constitution says in Article 11 that you can only spend money based on an appropriation, that has to be resolved and accommodated to the fact that the legislature or the court or the executive is given express powers by the Constitution, and there's an implied obligation on the state to fund its ability to do that.
So would that mean then that as long as the court provides temporary funding for the legislature, this impasse could last the rest of Governor Dayton's term?
It could.
And be perfectly consistent with the Constitution and
It
legal?
wouldn't be the hope. It could. As in all of those past cases, and true of this case, the idea was to provide temporary funding so that the parties could go back and negotiate and get a political resolution to the problem.
Well, it worked every time.
It has worked
and
every
we're
time.
rather early. Those other orders were all in the last week of June,
Right.
going back to 2001. And as you know, no appellate court has ever passed on whether that's even legal.
It's the law of Ramsey County, Your Honor. It's been the law since 2001, but you're right.
There are a lot of banks and checkbooks in Ramsey County.
There's never been an occasion because of the early resolution. The problem here, and why we worked out this stipulation, Mr. Kelly and I, on a very cooperative level, is that both sides have a strong belief that either the veto was or was not legal. Until that issue is resolved, the legislature, believing that it was illegal, is not going to come back and talk. The governor strongly believes that it is legal. So the impasse that's been created and why the temporary funding hasn't happened or hasn't been resolved by a new appropriation is that both parties on that legal issue, which we hope that the court will decide, have staked their position. If the court decides, as we ask, that the veto is legal, then the next step would be to go into a critical core function proceeding, as had been done in the other three cases. Issues would be the same. There's nothing unique about this case except the roles of the parties have changed. In those cases, it was the legislature who didn't appropriate. Here, it's the governor's veto who caused it not to appropriate.
Except in 2011, there wasn't a core function proceeding as it related to the legislative branch. Funding just continued at previous levels.
It
The
did.
core function proceedings only involved executive branch funding and particularized appropriations.
There is, however, in Judge Guerin's order, a statement of what the core functions test would be for the legislature, and I frankly don't know why the special master and the court didn't get to the legislative funding. I know it was continued.
I don't think anyone contested any of the items within the legislative appropriation
So
that
no
ran
issue to
out.
be presented.
That, as far as I know, I haven't found anything that would indicate otherwise.
So that's the position we find ourselves in. The reason there is an impasse, and we could go to a mediator, you could order us back into discussion.
Well, Judge Guerin also found that she had no authority to order you into mediation. Something called separation of powers.
Well, there is that, and I want to get to that. But the practical point we're at is that there is an impasse, and until this legal issue, which is really the barrier to any further negotiation or political solution, until that is solved, we don't think the parties are going to get together. So
Well,
theoretically, the temporary order could continue till the next legislative session. We would hope not. What we think should happen is either two things. If the court determines with finality that this is a legal veto, then we think the parties will get back together and negotiate. And simultaneously, if we're running out of funding, if the reserve funds are not enough to bridge the gap, then we would be back to you, and their counts 2 and 3, we have agreed that the court should institute at the appropriate time a critical core funding procedure so that they would not be obliterated. There's no intent or possibility that the legislative function will be obliterated. They're not put out of business because they have this constitutional right to get their core critical functions funded by judicial order. And so that, I think that's the premise that underlies their argument, and I think it's a false premise. And this case is really not different in the way it came about, but not different in the legal principles than those prior three cases where the court stepped in saying the constitutional duty to perform your function requires that the state fund it. And so there are two exceptions, or two ways that you can spend money. Appropriation is the common method, but by court order is, in an emergency, is the uncommon method. Separation of powers. I found, I hadn't read this before, the 1905 case State versus Bates to be the most helpful, I think, analytical framework for talking about it, because it divides our separation of powers, Article 3, into two separate clauses, or three separate clauses having three different purposes. The first clause is a distributive clause. It gives the power to the executive, the legislative, and the judicial. And inherent powers come with that distribution. The second clause is the prohibitive, which counsel has mentioned. No one from one department can exercise the powers of the other. But the third one is the most critical here, and that's the exception clause, except as otherwise provided in this Constitution. So the veto power, including the line item veto power, has to be looked at as an exception to the legislature's exclusive authority over legislative power. It is an encroachment. It's a constitutionally authorized encroachment, so that the governor has a role in the legislative function, and the line item veto more specific to the appropriation function. The court has said because it's an exception, it has to be construed narrowly, but that means, I think, construction of the Constitution. Is it authorized in this circumstance? Is it an appropriation? Is it an item of appropriation? Once that construction is done, and done narrowly, and in the interfaculty case, the governor's line item veto was not approved because it didn't really constitute an item of appropriation. Here, as you mentioned, the legislative appropriations are single line items. There's no doubt that they are items. Governor would have no ability to go behind those items. Number one, they're not particularly public to the governor what the itemization of the budget is, but he can't do a partial line item.
So is there any point at which perpetual and continuous vetoing of the appropriations to run the legislature would violate the Constitution?
Only if it's not an item of appropriation.
So the governor could abolish the legislature?
No, because the legislature can come in for funding from this court for its critical core functions, not for its appropriation, which I think is much larger than its critical core function cost. The legislature is always protected by the underlying constitutional right to perform its function, and the state must fund it, but not at the level of appropriation, but at the level of critical core function.
So taking it further, if the Supreme Court decided that all the Ramsey County judges over the last 17 years were wrong, and we can't fund anything, this is a strictly political fight, wouldn't your position be problematic with regard to the line item veto?
It would be very distasteful, for sure, but I think it would be legal. I think the veto would be legal.
So the government, the legislature could be shut down by the governor if there was no mechanism for emergency funding?
No, it can't be shut down. It can be denied an appropriation. The legislature can deny the governor an appropriation. The governor can veto an appropriation, thereby denying it to the legislature or the court. That doesn't leave them without funding, because then they come, as they've come 3 times in the last 17 years, to the court to say, we have to perform our constitutional obligations, and we can't do it without funding.
So you're assuming that the court's role to provide emergency funding is going to be legal in every circumstance, similar to what we've had in the past and today?
Yes.
Okay.
Yes, my argument assumes that, and I think it's true. And therefore, you separate out the veto from the funding issue. again, the underlying principle, you have a constitutional right to funding as a department of government. You don't have a constitutional right to an appropriation.
Is there any circumstance under which the reasoning behind a veto or line item veto would render that veto unconstitutional?
I don't believe so, and I think our cases are very clear on that. The Larson versus Carlson case says we don't look at the wisdom of a veto. Once we've decided that it meets the constitutional requirement of an item of appropriation, the inquiry stops. And why is that? That is a separation of powers requirement. So now getting to the prohibitive clause, the prohibitive clause is relevant, I think in this case, to the extent it limits the scope of judicial review. The court can't exercise executive power. The court can't exercise legislative power. And so if you inquire into the motive or intent of a governor in the exercise of a veto, or even inquire into the motive or intent of a legislative enactment, you in effect are exercising executive power. The governor has the power to veto or to rescind a veto. If the court is asked to invalidate a veto, it must exercise executive power to do so.
Well,
And that violates separation of powers.
In the Birkeland versus Christensen case in 1930, the court talks about the fact that there is the power of judicial review to determine whether the actions of the other branches are consistent with the Constitution, and one branch can't coerce the other branch. So how do you jibe the argument you're making with the principle that I can't look at the motives? How do I know if there's improper coercion if I can't look at the motives?
What a slippery slope that would be. To
Potentially.
begin to look at the motive. Not only a slippery slope, I think a cliff, frankly. You can't step over that line without invading the province of the other department of government. If you look at the motive, then you are into the political discussion, the political reasoning of the governor, which is within his sole discretion, so long as he is acting within the power given to him by the Constitution. And this is a specific power given to him to do a line item veto.
So that gets back to the question that's in my notes that Mr. Kelly asked. So can the governor veto funding for the courts and put in the veto message to the legislature that I am not going to sign a bill funding the courts until they either reverse a decision that they made, or if it's a pending decision, rule the way I want them to rule?
I think he can veto, but I don't think he can defund the court. And the court would have the right, as it has had to do, at least in 2 of those past cases, come to this court and say we need critical core functioning, or we can't exist as a constitutional body.
So if the governor doesn't
as
get
I say, that would be a very unsavory thing for a governor to do, and it is the extreme, but it's nothing near what we have present in this case today.
Well, what's the difference between the governor saying I will veto funding for the courts until I get the outcome I want, and the governor saying I will veto funding for the legislature until I get them to revisit legislation that I didn't like? What's the difference?
I don't think there is any difference in terms of his power to veto. The difference here, though, isn't unsavory, as your hypothetical would be.
Well, I tried to pick the most distasteful, unsavory example I could come up with, because sometimes these principles have to be tested by their extremes.
By the extremes. And I would say, as distasteful as it is, I think the governor has the power to veto. There is no constitutional principle that limits it, unless he were to obliterate that branch of government. And he can't do it. He doesn't have the power to do it, because that branch of government has the constitutional right to be funded for their critical core functions.
So we would basically then, in the example I gave, have to wait out the governor's term as those vetoes come and applications to the court for funding are made. And if the next governor doesn't care about that court decision, then peace would then prevail. That's perfectly okay as far as the governor is concerned under the Constitution.
It's perfectly okay under the Constitution. Our governor would not support that political view. But it would be a political decision of the governor to do it, and he has the power to do it. And the remedy of the court or any other body that has failed to get an appropriation, as it has been in 3 prior cases, when the court did not have an appropriation, the remedy was to come in and get their critical core functions funded. So they are not without a constitutional remedy. They are protected. Therefore, their continued viability as a body in the government is preserved and guaranteed. But it's guaranteed in that way. It's not the right to an appropriation. Appropriations either within the discretion of the legislature or subject to a veto of a governor. Each of them acting within their discretion as has been conferred to them by the Constitution. And the remedy being then to get funding in a different mechanism, not through an appropriation, but through a court order.
All right?
There's been much talk about why, if you put limits on a veto, then what effect does it have? Or is it improper for a governor to veto a bill to accomplish something secondary?
Well, that's another question, is because
It
you would
is.
agree that the policies that the governor objected to in his letter could never be line item vetoed because they aren't appropriations.
Right.
So the governor can do indirectly what he can't do directly. Is that
Absolutely.
okay?
And I think it's a little hypocritical for the legislature to make that argument because look at the revenue bill and the defunding potentially of the revenue department. They said if the governor doesn't sign the tax bill, the appropriation to the revenue department is gone. It's only effective after the tax bill becomes effective. Now, did they object to the amount claimed in the revenue department's budget? No, there was no objection to that. They weren't saying you're spending too much money. They used the poison pill to defund the revenue department potentially in order to get the governor to sign the tax bill.
Was that
Indirect.
unconstitutional?
I don't believe so.
So you could still sue to have that
Had the governor
taken care of?
Pardon?
So the governor could still sue?
No,
He signed the bill.
you asked, was it unconstitutional? I said, no, I don't believe it
You don't
is
believe-
unconstitutional.
okay.
I think they can indirectly accomplish one purpose through another mechanism.
Well, is there
If
a
you-
way that, except the distinction is that the governor can't line item veto policy provisions? That is unconstitutional.
Right.
Is there anything unconstitutional about what the legislature wanted to do that would have made it unconstitutional to do it directly, but constitutional to do it indirectly? I'm trying to find the analogy. That's all.
We were very disappointed with what they did. We thought it was a breach of trust, but we didn't believe it was illegal for them to do it.
Okay.
And it presented the governor with this choice. I don't like the tax bill. There are at least 3 things in it. If I had a line item veto, I would line item veto it. But if I veto the whole tax bill, I'm jeopardizing 1,300 employees that work for the Revenue Department and the function of the Revenue Department to serve taxpayers and collect revenue. Now, he would have had the remedy of coming to this court to get emergency funding for the Revenue Department because it is a critical core function of government. But he'd gone through that process in 2011. It was a difficult process, and he made a political choice to say, I'm going to avoid the temporary shutdown of the Revenue Department and sign a bill that is distasteful to me, but in order to get the legislature to come back because they haven't listened to my objections, they haven't reflected my concerns in that bill, so we should discuss that more, I'm going to veto their appropriation as a mechanism to get them back. He did object to it. This question about the word object in the old version of the Constitution simply means state your opposition. That's what the word object means, even by the definition the plaintiffs have provided. He did state his opposition to it. He was opposed to it for a number of reasons. He said, you haven't finished your work, so I'm not going to appropriate money, approve the appropriation of money to the legislature when your work is unfinished. Yes, it was in his budget, the amount, but that was under the assumption that the legislature, this legislative session was going to be fairly conducted. He wouldn't be faced with this Hobson's choice, either do or don't do. And he felt that that had been breached and that they hadn't done their job. So at the point he vetoed it, he did object to their appropriation.
Well, he didn't object to the dollar amount of the appropriation or to the use of the money, and that really goes to the bright line rule that Mr. Kelly would have the court adopt, and that is if you don't object to the appropriation itself, but you are vetoing the bill for some unrelated purpose, that's the definition of an invalid veto. And what's your reaction to that?
Well, that's why I say it's exactly what the legislature itself did when they put the poison pill to defund the Revenue Department if he didn't sign the tax bill. Indirect government action is replete in all of our laws. Look at our tax laws, for example.
Yeah, but the difference is that the legislature has the authority to legislate and the governor doesn't. And as you pointed out from the State v. Bates case, the third item, the exception, the veto or line item veto, has to be construed narrowly. So if your objection isn't to the appropriation, then how can you use this very narrow authority to accomplish some other result that you agree is forbidden if done directly?
I don't agree that it isn't to the appropriation, number one. He said, you haven't finished your work, so I'm not going to appropriate to you until you finish your work. So it is to the appropriation. But secondly, I believe he can make a veto, use a veto for one purpose to accomplish something else.
Okay.
And that's the nature of a veto. If the court were to begin to look at the intent or political motivation of a governor behind a veto, there can be no bright line that would exist that would embrace the court's authority to violate separation of powers and enter the political decision-making of another branch of government. Once you talk about motive or intent, then you're getting into the political deliberations of that other branch. And I think our cases, the Johnson case, the Duxbury case, the McConaughey case, all come to that conclusion. You can't second-guess the reasons why a legislator uses its power, a governor uses its power. That would be separation of powers. Interestingly, the McConaughey case was quoted in the West Virginia case that counsel referred to, but not followed, because West Virginia law is not like Minnesota law. In Minnesota, under McConaughey, there is no role of the court to second-guess a political decision made by the governor. In West Virginia, apparently there is, but West Virginia has a completely different budgetary constitutional structure, much stronger role of the governor in the front end of developing the budget, and then a much weaker role of the governor in vetoing it. He can't veto, the court said, anything relative to the court. He can't veto anything relative to the appropriation of the legislature. So it's simply not a comparable case. It does give me comfort, however, to know that if you scour the country to find a case that authorizes you to do what the plaintiffs have asked you to do and validate a veto on a motive basis, you can't find a case that is comparable to Minnesota's Constitution. You find a 1973 West Virginia case that isn't even comparable. There are no other cases out there, certainly none from Minnesota, and all of the Minnesota cases say that the motives and intent of the governor behind a veto, once he meets the threshold, this is a veto of an item of appropriation, is beyond the power of the court to consider, because that would itself invade the province of the executive and be a violation of the separation of powers.
All right.
Perhaps just a moment on the stipulation. As I mentioned earlier, the governor's reasoning and desire to be part of the stipulation is the conclusion that the parties had reached an impasse and could go no further until this legal issue of the legality of the veto is determined. There are other benefits in the stipulation, the commitment to the Senate rent payments, supports the bond rating. The governor was not intending by his veto to deny funding to the legislature. He obviously was aware they could come to court and get funding, but in order to allow for the parties to pursue this legal question while not simultaneously starting the critical core function proceeding before this court, which may or may not be necessary depending on the final outcome of the legal question, it just seemed to us to be the appropriate solution that for a 90-day period, we would continue the old appropriation, not embrace the new appropriation. If that stipulation is not accepted by the court, if we don't have that temporary, then the relief that we've asked for, and of course the way we briefed it, because that was before the stipulation, is dismissal of count 1 with prejudice on the finding that the veto was legal. To the extent counts 2 and 3 rely on reinstating the appropriation, we would ask those be dismissed as well. To the extent they ask for critical core funding under the principles of our prior cases, we agree they're entitled to that. They have a constitutional right to that, and we would support the commencement of a proceeding to have that determined.
So the difference between the position the governor took in 2011 and the position that the governor took now in the pre-stipulation world is that the governor did not parse out individual items of core critical funding for the legislature in 2011, but now takes the position that but for the stipulation there would be a dispute. Is that true?
I'm not sure it's a true statement of what the governor did in 2011.
Okay.
The governor may.
I didn't see any evidence
It's not apparent from the order how the funding to the legislature was resolved, whether that was by agreement of a number of parties. There is in the order, as I say, the judge said there identifies what the critical core functions of the legislature would be: to devise craft laws, to debate laws, to publish, and to pass them, and to publish them.
And then the order just said, pay it. And I have an affidavit in this case which says that the legislature was funded at its existing level during the course of the litigation. So I didn't see anything to dispute that, and that was one question I was going to leave with each of you. Are there any disputed facts in this case?
I don't believe there are any disputed facts that would be material to the issue of the legality of the veto.
Okay.
If we got into a critical core function, then I think there are facts to be determined, and we've tried to provide some basic facts to show that not everything in the appropriation requested by the legislature would qualify as critical core function.
Right.
But if the stipulation is accepted, we don't get to that issue.
Yeah, and the way you both presented that stipulation to me, it says if accepted, and I'm going to go through my own analysis of whether I could independently do this even if you hadn't stipulated to it, similar to what my predecessors have done. I don't know what will happen after here. You've agreed, so neither of you are going to appeal anything that's consistent with your stipulation. I don't know if someone would intervene later and challenge it. At the appellate level, I have no idea. So that's why I'm going to go through my own analysis, and if I follow the stipulation, it'll have its own supportive reasoning.
We understand that we can't confer authority or jurisdiction on the court by our agreement, so that's why we framed it in that way. But we believe that you do have authority. And I think judicial economy and the court's inherent power over judicial economy is a driving factor behind that. If you don't accept the stipulation, then as we say, we should immediately go into a critical core function proceeding. Now, that makes very murky the question whether the legality of the veto can reach an appellate court while that's pending. Perhaps with a Rule 54 certification, there's no reason to delay entry of a final judgment that could be separated out. But that would be a several weeks, maybe several months process, which may be negated by any ultimate decision. And so for reasons of judicial economy, and I think serving the parties who are all public parties and therefore serving the citizens of Minnesota, I think you have the power to do it.
Well, and if the parties get a third party, perhaps a retired judge involved to help them mediate this dispute, you could resolve it even sooner.
I think that could happen, but I don't see it happening and while this legal question is unresolved. Is the veto legal or not? The legislature has very little motivation to come to the table if they believe it's an illegal veto and that their appropriation will be restored.
Well, the flip side is true, and the best settlements are reached in an atmosphere of uncertainty.
Very true.
All right,
Thank you.
Thank you. Mr. Kelly, any final parting thoughts?
Just a few, Your Honor. I have to say, I think that is the most expansive delineation of executive powers for a governor that I have ever heard. And you're posing to Mr. Hansen the hypothetical, is it okay to veto the judiciary's budget because he doesn't like something? And the answer was yes. I think that's clearly out of bounds. And the fallback position that somehow we're all safe because of the core functions, let me just say, that is a very disruptive, it's inimical to the efficient running of government to have it. And as I said before, I quoted from this, the governor himself, Mr. Hansen said, you know, he didn't like what was going on before. He wasn't going to put the executive department through it. He says, I will not risk a legal challenge. So the premise here is somehow that, oh, we're not obliterating a legislature, we're not doing away with them because you can always go to court. The governor himself didn't want to do that.
Well, one of the governor's linchpins here is the availability of court assistance in gaining temporary funding, and that as long as you have temporary funding, and that goes to a well-known doctrine, the doctrine of judicial restraint. Why should the judiciary get involved in a political question when it can, by injunction essentially, mandatory injunction, keep the core functions of government going while these political issues are addressed?
Well, I think you heard my colleague say as well that we're not going anywhere here unless you solve this question for us, I think, in terms of that's why we have done so much to tee this up for you to say, call the balls and strikes. That's what the court does, and I think they're clearly out of bounds. When he talks about the poison pill and how that put the governor in a bad spot and et cetera, you know, the governor had a very simple resolution. Veto it. Veto the whole dang bill. Just do that. And then the parties would have been back into the legislative area. You know, we are used to some really sharp elbows in this state between the various branches of government. We've seen that before in the Mattson case and in the funding cases and the other ones. I think the expansive view of executive power that you just heard should not fly and shouldn't get anywhere. And in your position, if you go back to Baker versus Carr, and I know we don't have, basically the political question issue is different, but if the court there, the U.S. Supreme Court said, if the government acts in a matter repugnant to the Constitution, the court has the authority and the duty to step in and uphold the Constitution's mandate. That's what I'm asking you to do here today, Your Honor. I'm asking you to resolve this dispute and I think it will be for the good of the state of Minnesota. We're asking you to declare his line item vetoes null and void. Thank you.
Thank you. Matters under advisement.